Chief Judge and Associate Judges now presiding on the District of Columbia Court of Appeals. Please draw near and give your attention. God save the United States and this honorable court. This honorable court now in session. Please be seated and come to order.
Good morning and welcome to the District of Columbia Court of Appeals. We have 3 cases scheduled for oral argument this morning. The first case is in re Joel D. Joseph. Are the parties ready to proceed?
Good morning. May it please the court. My name is Joel Joseph. After graduating from Georgetown Law School in 1973.
Mr. Joseph, may I interrupt just very briefly? Would you like to reserve any time for rebuttal?
Yes, about
Okay.
5 minutes.
Okay, so we'll watch your time for you.
Thank you. After graduating from Georgetown Law School in 1973, I passed the DC bar that same year. I was hired by Professor John Banzaf at George Washington University to teach with him a 3rd-year seminar on litigation and to work with him on anti-smoking cases. I lived in DC from 1970 until 1980 when I moved to Maryland. I practiced law in the DC area for 33 years. I also argued cases in 25 jurisdictions across the country, mostly in federal court. When I was working for a client in Santa Barbara, California, I met Arthur Wartell, a Vietnam veteran and a taxi driver.
Mr. Joseph, I think we're pretty familiar with the facts that led to your disbarment. And I think what we're here to consider today is whether you can satisfy the Roundtree factors. And so I'd invite you to turn your argument to those, please.
Okay, I can address the Roundtree factors. Let's see. Okay. Before I address the Roundtree factors, I want to turn the court's attention to the Board of Professional Responsibility in Ohio that conducted hearings on these same issues. And it's in the record. I want to turn to paragraph 7 of their findings. Paragraph 7 said, petitioner presented evidence at the hearing that in this matter that demonstrated that he held a Maryland driver's license, that he filed income taxes in the state of Maryland during the time in question, in which the Maryland Court of Appeals determined that he was a resident of the state of California. And then finding 13, based on the evidence presented, the panel unanimously finds the petitioner has satisfied all the requirements for reinstatement to practice law in the state of Ohio, except one. Petitioner has not been reinstated to the practice of law in the state of Maryland. Ohio has the same basic standards that DC has in re Roundtree. In that ruling, the court said, quote, under the rules governing this bar, the court must decide whether petitioner is fit to practice law. To make that determination, we must conclude that he has the moral qualifications, competency, and learning in the law required for readmission. I have met those requirements. I have the moral qualifications, competency, and learning in the law. Concerning moral qualifications, I've always practiced law morally and represented those who could not afford counsel.
So in that vein, can I turn you to the hearing committee's findings that you had represented to the DC Circuit, that you were in good standing with the DC Court of Appeals when you were not, and then also you had engaged in the unauthorized practice of law, collecting money from, I believe it was clients Francis and Ortega, who thought you were actually a California attorney.
First of all, I never represented to him that I was a California attorney. And I was basically a law clerk for him. And I filed a Freedom of Information request. He had counsel in Ohio who was admitted in Ohio. I never represented to him that I was an attorney. at the time.
What did you tell him?
Excuse me?
What did you say to him? Because the hearing committee made a finding that you did hold yourself out to be an attorney and able to represent him in his legal action.
First of all, he was hired, he hired me on Upwork, which is a internet service. And I didn't say at any time that I was an attorney, and I didn't charge
What
what an
did you say
attorney
to
would
him?
charge.
What did you say to him?
That I would conduct legal research for him as a paralegal and submit a freedom and help him with the Freedom of Information request.
I mean, counsel, we're not a fact-finding body generally. So do you disagree that the hearing committee found that you represented yourself, held yourself out as a lawyer in that representation? And do you think that that was, or do you just say that that wasn't based on any record evidence?
That was not based on evidence. It was not true. I did not hold myself out as an attorney at any time to him.
Okay, but you don't dispute that the hearing committee made a finding along those lines. And then I think one thing disciplinary counsel says is your brief, your initial brief, really didn't make any dispute of that fact. You're raising one now, but they said, well, you've waived any challenge to that factual finding because you didn't say anything about it in your brief. Do you have a reaction to that?
Well, first of all, he didn't testify at all. The person that hired me didn't testify to any facts whatsoever. There was nothing in the record that said I held myself out as an attorney.
But I'm looking at page 86, and the question you were asked is, your response to this client was, I am an attorney, and you said correct. So you concede, I think, on page 86 that you held yourself out to be an attorney.
That's not correct. That is not correct. I did not hold myself out to be an attorney. I might have said that I graduated law school, and then I'm capable of doing legal research, but I didn't hold myself out. And I definitely told him that I was not admitted in California. He knew that. And there was no case in California. He had a case in Ohio, and he had Ohio counsel. So there was no need for me to be an attorney.
Well, Mr. Joseph, there are a number of findings in the hearing committee report about statements and your conduct and representations made that the hearing committee found related to the honesty factor. But let's move on to your conduct since disbarment,
Okay.
where there was a complaint filed against you for the unauthorized practice of law and for some of the other statements that you've made in the District of Columbia, specifically that you were reinstated to practice in the District of Columbia.
I'm not sure what your question is.
Was an unauthorized practice of law complaint found against you? And did you indicate that you had been reinstated to the practice of law in the District of Columbia?
No, I didn't state that I was reinstated. And I was reinstated twice, even though the bar claims that it was not appropriate. They did reinstate me twice. Let's see. Concerning moral qualifications, I've started 4 nonprofit organizations, and I've always worked for the public benefit. I started out my argument saying I represented Arthur Wartell, and that's the case that triggered this entire thing in California. He said that he could not find counsel to represent him, and I said I would represent him. He was a Vietnam veteran who had suffered medical malpractice. And I pursued the case for him. I filed the proper complaint with the Veterans Administration to get compensation. They gave a right to sue letter. And I did obtain counsel in California, and they backed out. And so I actually went to California to get local counsel because it had to be filed in March of 2007. And I hired Robert Moss to be local counsel. I did all the work on the case. I obtained a $100,000 settlement from the Justice Department, and Mr. Moss didn't do any work on the case whatsoever, even though we had an agreement that we'd be paid according to the work performed. And because of this, this is how the whole thing started. He filed a complaint against me. Actually, he was too cowardly to file the complaint. He had his secretary file the complaint against me with the Maryland
Mr.
Bar.
Joseph, you're not allowed to challenge the circumstances underlying your discipline in another jurisdiction in a reciprocal discipline proceeding. I think we said that in the opinion disbarring you. So I don't think it actually matters your challenges to the Maryland action now, correct? I mean, I think what you really need to do is to demonstrate to us that you've established that you meet the Roundtree factors, not relitigate your Maryland discipline.
I think it does matter that I was inappropriately disciplined by Maryland. I think it does matter that the peer review committee voted 3-2 to proceed, so they had a slim basis for proceeding. I do think it's important that the judge they submitted the case to in Montgomery County rubber stamped the findings, proposed findings of the disciplinary council and ignored my proposed findings. I think due process is important. The underlying facts should be important to this court in pursuit of justice. And then the Court of Appeals in Maryland ordered Judge Dugan in Montgomery County to consider my proposed findings, and he didn't. He still didn't. And they relied on his rubber stamp of bar counsel's findings.
Is there anything else you want to say about the Roundtree factors that
Okay,
this court must consider before we reserve
I want to
the
go
rest of
back
your
to
time?
that. I believe I'm very competent to practice law. I keep up on the cases. I read every Supreme Court case. 5th edition of my book on the Supreme Court, Black Mondays, is going to come out. These are the uncorrected galleys. Let's see. I recently completed another book that involved a lot of legal research called Solomonic Justice. It's about the Israeli Supreme Court. I worked with retired Israeli Supreme Court Justice Eliezer Rivlin, and in Exhibit 11, he stated, quote, "In this book, Joel Joseph masterfully analyzes some of the most prominent decisions of the Israeli Supreme Court and brings them gracefully to light. Solomon's wisdom, both just and humane, is displayed in Israeli Supreme Court decisions," notes the author, "in a court that is balanced, considerate of opposing interests, and open to all."
Mr. Joseph, one of the Roundtree factors is recognition of the seriousness of the misconduct that led to your disbarment. And I hear you here today challenging that. So do you recognize the seriousness of the conduct for which you were disbarred?
I do not believe that I committed any misconduct. I was a resident of Maryland when the petition to proceed pro hoc vice was filed. The Ohio court found that I did demonstrate that I was a resident of Maryland at the time. And so, you know, Maryland doesn't want to readmit me because I don't want to admit that I violated any principle of law or ethics, and I didn't. So I'm unwilling to confess to a crime that I didn't do. And so if you want me to admit that I did something wrong, I'm sorry, I can't do that because I was a resident. I had moved to California. I traveled to California in February of 2007. I didn't know if I was going to stay there or not. I met my wife March 25th of that year. And after I met my wife, I decided I wanted to live in California. But at the time the petitions to proceed pro hoc vice were filed, I didn't know that I was going to become a California resident. So I don't want to admit something that was false.
So
All right.
when you say that the Ohio disciplinary authorities agreed with your arguments on the merits, where in the record is that?
Yes, they did.
Where in the record is that?
Excuse me?
Where in the record is that?
It's, let's see. I think it's Exhibit 9.
Thank you.
I'm not exactly sure, 100% sure of the exhibit number, but I've got a copy of the order from the Ohio board. I want to reserve the remaining time for rebuttal.
All right, thank you, Mr.
Thank you.
Joseph.
Morning, may it please the court, Bill Ross on behalf of the Office of Disciplinary Counsel. Mr. Joseph has the burden in this reinstatement proceeding, and he has not addressed any of the hearing committee's conclusions of law, despite invitations this morning, despite multiple opportunities in his briefing. And disciplinary counsel, as we've stated in our brief, believes that he's waived those arguments. As the court has noted, this is all about the Roundtree factors, and at the hearing committee found that he had not satisfied any of those Roundtree factors, and their findings are all supported amply by evidence in the record. As the hearing committee found, the traits that led to the disbarment still exist. He's continued to have a lack of forthrightness. He's engaged in the unauthorized practice of law, and he's continued a history of vexatious litigation. In this case, there were no live character witnesses with knowledge of the misconduct or the ability to testify to his current character. That in prior cases alone is reason to deny reinstatement.
So you in your brief press that he has waived any analysis of the Roundtree factors by not, I guess, challenging the hearing committee's conclusions before us. So would you prefer that we go out on waiver or that we address the Roundtree factors if we were inclined to side with you?
I think the hearing committee has already addressed the Roundtree factors, so it really doesn't matter. Disciplinary counsel would like you to adopt the hearing committee's recommendation, regardless of either whichever route that is.
Can you talk to me about the fifth Roundtree factor for a moment? I mean, one thing that Mr. Joseph says is, look, my competence is really not in question here. His disbarment was really not based on anything related to his competence either. But I mean, I understand the hearing committee says he hasn't demonstrated that he's competent to practice law. If we disagree with the hearing committee on that, would that change the bottom line?
No.
Can you tell me what evidence supports the finding that he isn't competent and doesn't have the qualifications? Because I understand the record to sort of look like this. This is a competent lawyer who's qualified to practice law, but for some seeming pathological dishonesty, that he is not candid with the court or his clients, and that is what led to his disbarment. But one Roundtree factor is sort of the first half of that, which is, are they competent? Do they have the qualifications? And what in the record says no?
The hearing committee found that his brief to the hearing committee alone was evidence of his lack of competence, because it made mistakes on the record and was focused on entirely the wrong issues. That was the same brief that he filed again before this court. And also,
I happen to think a lot of competent lawyers probably aren't going to do a very good job in their own disciplinary committee. You know, the world needs transactional lawyers as well. And they can write a brief about as well as I can write a contract, which is to say, I'm sure we'd both be incompetent at those activities. So I don't know how far that gets you.
well, and that the hearing committee also pointed out that he didn't submit any evidence as to, he had his own statements, but he didn't submit any evidence of courses he'd taken or steps he'd taken to maintain his competence. And he had
I was
history.
curious about that because one of the findings was he didn't take essentially CLE courses or credits, but we don't, where DC bar members have a requirement for CLE classes or courses, as do some other jurisdictions. And so I was curious why that was a basis for a finding of his lack of competence to practice.
That alone was not a disqualifying factor, but I think that was the committee grasping at what could he have shown, and there was no showing at all. So that would have been some evidence. His continuing vexatious litigation cuts against this as well. but there was no evidence about steps he's taken to maintain his competence.
Well, but was he required to show steps to maintain his competence if his competence was never called into question? As Judge Steele said, the focus of his disbarment and the underlying causes dealt with more characteristic traits like honesty or lack of candor with the tribunal.
Correct. I think in every case, we have to look at each of the Roundtree factors, and there should be some evidence in the record.
So if he meets one Roundtree factor, is that sufficient?
No, it's not a mathematical test. There's no exact calculus, but each of the factors has to be met. So if an attorney has a lack of character, but is exceptionally competent, that still doesn't satisfy the Roundtree factors. Or if the attorney doesn't recognize the seriousness of the misconduct, and the court has no sense that future misconduct would be avoided because of that failure to
Recognizing, I'm sorry, recognizing the seriousness of the misconduct often cuts both ways, because Mr. Joseph is not the first attorney to say, why should I be forced to say I did something that I didn't do? And if someone adheres to the fact that they believe that they practice lawfully and adequately and doesn't bow down and fall on their sword and say I did wrong, where does that leave us, I guess, in our assessment of the Roundtree factors?
The biggest case in that regard, I think, is Sabo, where the question was about the attorney's state of mind at the time of the misconduct, and the attorney recognized that the misconduct that was found was very serious. We have a very different situation here, where Mr. Joseph continues to relitigate the underlying misconduct and turn it on its head, instead of looking at the language of the false statements that were made in California, where he said, I have no connection to California. He's asking the court to turn that around to say, but I had some connection to Maryland.
Well, one thing I found interesting about the findings, they're sort of slippery. The statements on which the findings of the hearing committee were based were sort of slippery. They're sort of half truths, almost truths. Is there a statement that was sort of undisputed in the record that you could point to that was a bold-faced lie as opposed to a lack of candor? Or because he says, well, I wasn't planning to stay in California, I was there. I told the person I would represent them in their case and do legal research, but I never said I was a barred licensed attorney. So there are all these little hedges that some might argue were not direct, bold-faced lies in this instance.
The best example that I can point you to is the Pro Hoc Vice applications themselves, where he certifies that he didn't have, and I don't have the exact language in front of me, I apologize, but he didn't have a residential employment or other connections to California. And he did. Each time he had an apartment, he was living there. He was employed there. He had a driver's license there. He'd registered his car there. California found that these were the types of things that certification was asking for. And indeed, interspersed between several of these applications, he filed a lawsuit and said that jurisdiction was proper in California because he was a resident of California. So those are not mild misleading statements. Those are directly dishonest. If there are no further questions, disciplinary counsel relies upon the excellent hearing committee report and the briefing in this matter. Thank you.
Thank you.
Bar counsel stated that I didn't submit character witnesses, which is false. They didn't give live testimony, but Reverend Jesse Jackson wrote a very good letter. He wrote it to the Maryland Bar, but we submitted it as an exhibit. He's known me, and he stated that he's known me for 25 years and that I'd make a good addition to the bar. I don't know that many people that could present somebody as strong and as in the public interest as Reverend Jackson. Concerning what Bar Counsel said, I misstated. He misstated the facts. When I filed a pro hoc vice motion in California, I was not employed in California. My car was not registered in California till later that year. So those are misstatements that Bar Counsel made. And I assume you're not going to discipline him for making those false statements. But I stated accurately, I didn't even file the motion for pro hoc vice. My local counsel filed it for me. But at this point, I'd like to thank the court for giving me this opportunity to present my case to the court. The Maryland Court of Appeals has not allowed me to present anything for the last 15 years. So I do appreciate. And let's see. Going back to the Roundtree factors, the Ohio Disciplinary Committee addressed the same factors and found that I'm competent to practice law, that I'm ethical, and that I would be a good addition to the bar. I feel that I would be a good addition to the bar here, and that I do think it's relevant that I was inappropriately disciplined by Maryland. And if you don't have any
I
more
have
questions.
one question. I believe in your brief, you say that you were admitted in the Second and Seventh Circuits. Is that correct? And I'm wondering how you can be admitted in a federal court if you don't have an active state license.
Yeah, I'm still admitted to the Second Circuit. I argued before the Second Circuit about a year and a half ago.
Are you admitted in any state?
No state at this time. But the Second Circuit and some of the other circuits, even though they were presented with the same materials that you or didn't discipline me. I think I was admitted to almost every circuit in this country and argued before almost every circuit. And I think about 3 of the circuits still have me as in good standing.
All right. Thank you. I'd like to thank
Thank you very much.
counsel and parties for your briefs today and the cases taken under advisement. All right, our second case this morning is Joseph Mancuso et al. Versus Chapel Valley Landscape Company et al. All right, before we proceed, I'd just like to hear from counsel for appellees as to how you plan to divide your time this morning.
10 minutes for myself, Your Honor, Howard Meister, on behalf of Chapel Valley Landscape Company, and 5 minutes for co-counsel.
All right, thank you.
Thank you.
All right, Mr. Schwartz, are you ready to proceed?
I am, Your Honor. Morning, Your Honors. My name is Frederick Schwartz, and I appear on behalf of the MANCUSOs. Let's address first, if we can, the elephant in the room, and that is how the Superior Court judge, in essence, usurped my client's cause of action, or at least the case that she had, and then decided against her. There's no legal precedent for it.
What are you referring to, the DCRA?
No,
findings?
Your
What do you-
Honor.
what do you mean?
I'm referring to the dispositive case in this matter. The dispositive decision she made is that under the subordination clause or rule, that my client's case belonged in essence to Progressive, which was their insurance carrier. And consequently, they had no permission or right to bring the case.
Right, but let's look at that claim, because I think that is the heart of the case there. There are 2 aspects to that. I mean, there's no dispute that Progressive paid for the damage to the vehicle, which was totaled when the garage collapsed on it. And so your clients recovered from Progressive for that. And Progressive claims that your clients therefore had no right to go after Chapel Valley or Grunley because the claim for reimbursement for damage to the vehicle was subrogated to Progressive, right? You're not disputing that part of the subrogation language interpretation.
Well,
You're talking about other damage and that they allege, right?
if I could, Your Honor, Progressive wasn't in the case. The two people that alleged that, or the two parties that alleged that were the defendants. in
Right, but
this-
there is language in the Progressive contract that clearly says that when the insured, that's your clients, accept payment for damages from Progressive, that any claims to further claims with respect to that damage that was paid are subrogated to Progressive. Right?
Oh, there's no question about that. There are in fact two clauses, but subrogation was not based on the subrogation clause. The first clause, as I point out in my papers, is the subrogation clause. And they utilize the subrogation clause to go to arbitration in order to see what they could recover from the two defendants. They settled with one defendant and they lost in arbitration as to the other defendant. Then there is a contract clause. For example, I don't get full payment if my car is injured. They take 10% off the top. And under that contract clause, it says that if my client went to court and won, that the amount that Progressive did not receive, they could recover under contract, not subrogation, under contract. So there are two elements we're looking at, and we don't deny either of those two is being correct. But the requirement is that my clients be allowed to go to court. That's what the collateral source rule says. It says you can go to court and
We
doesn't
have
matter if
cases
you
that say
recover.
the collateral source rule doesn't apply if there's a subrogation clause
Well,
in an agreement.
it does, Your Honor, in two ways. First, in relation to this court or this case, because in fact, Progressive is only permitted to receive part of any recovery. The part that they paid out in our position is the part they paid out minus the $12,000 or so that that Progressive recovered in their subrogation action, but the rest of it belonged to my client. You know, I would agree with you that the subrogation provision and the collateral source rule are in somewhat of a tension. However, it could also be a strategic truce because it doesn't happen that often.
So with the amount, you said it's about $12,000 over and above the amount that Progressive paid your clients for the damage to the vehicle. They had personal property that they were seeking reimbursement for. Your argument is that they were not precluded from filing an action against Grunley and Chapel Valley to recoup that additional amount.
Well, again, I think the way it would work, Your Honor, in terms of procedurally, typically the carrier will go against the tortfeasors under subrogation, and they have this mechanism between them to save money, and they go to arbitration, and there's a settlement in relation to arbitration. And that's under subrogation, and that was the first paragraph of the quoted language in my papers. The second is a contractual right that Progressive has, and I don't know whether in fact the other carriers have it, but it's a very clever right. The right is, we have a contract. We say that if you go to court and you win and you have a recovery, we're entitled under contract to that part of the recovery that makes us whole. In fact, they're made whole because of the premium they charge. But in any event, that's what the clause says. And we're not debating that. But my clients in this kind of an unusual case had substantial monetary claims above and beyond what the Progressive would have obtained. And the defendants argue that, well,
Mr. Schwartz, is it above and beyond what Progressive would have received from the defendants, or is it above and beyond what Progressive paid them? I think what we're trying to tease out here is it just the claims for personal property or the golf clubs, or are you saying that they can recover kind of fully for the cost of their car, even though they already received that from Progressive?
well, I think what I'm saying is this, Your Honor, that my clients would recover everything that they would be entitled to. That's what the collateral source rule says. It says we do not deduct what you get for the damage to your car in this case. But then Progressive had a policy language, and the policy is just a contract. Progressive has a policy language that says if you go to court and you recover that chunk of it that we would get under subrogation. In other words, that chunk of it we give out, you have to give back to us, but you're entitled to the rest of it. It's not as if the cause of action goes under subrogation to the carrier. The cause of action stays with them. Otherwise, there's no collateral source for it because there would be no need for it.
Did your clients seek reimbursement from Progressive for the additional damages to their personal property? And if so, was that claim denied, or is it that they never made that claim to Progressive?
That was denied, and it's not in the record. There are two pieces of the additional amount. One is the personal property and the deductible, which they did not receive. And the other is a diminution in value of the parking space. And that's what they're trying to recover in addition to the damages that they received to their car and did recover from Progressive. Progressive is their carrier. Progressive, if it was involved, needed to be involved in this case. That's what the rules say. And the court made a decision on Progressive's part. Now, let's assume, hopefully, that it's in court. My client wins, they get the recovery, the full recovery, and then we work out a deal with Progressive in terms of how much of that subrogated part they're entitled to recover. For example, they already got $12,000, so they're not entitled to recover that. They may, and the language provides it, the language says we may bring an action against you, but we wouldn't wait for that. We just work out with them how much they think they're entitled to, because we have certain claims against Progressive.
When there was a settlement, what did the release look like? Did it not release any of your clients' claims? When Progressive settled with the insurance companies, my recollection of it, the document in the record says that they settled as subrogee of the MANCUSO's ASO. I'm sorry, maybe ASO. Yeah, as subrogee of. But I don't recall there being any release signed by your clients. Is that right?
Right. They signed a release and they said, we have no more claims against the defendants. I mean,
Progressive signed a release saying we are foregoing any further rights of subrogation that we have. We can't go after you for this amount, insurance companies. But there's nothing in that release that said, in your view, when it says as subrogee of them, that we're sort of in privity with them too, and therefore they have released that portion of their claim. That's not part of the argument here.
well, that's pretty much it, Judge Steele. It gets sort of into the weeds because they signed a release with the defendants. Progressive did, and they said, this releases all claims we have against the defendant. And it's true. they released all claims they had against the defendant under their rights of subrogation. But I think what they're going to argue is, well, this is just a chunk of money you won in court. And under our contract with you, you're entitled, we're entitled to a chunk of money. But that chunk of money loses its identity with the two defendants. It's money that they recovered. And let's say it's a general recovery instead of a specific recovery, and it's $40,000. Then this is money that belongs to my clients.
So that
But under the
doesn't seem
contract, they have
to
promised.
reconcile with how subrogation works. So let's take the car, for example. Your clients had a claim for the car. By virtue of the subrogation clause in the insurance contract, they gave that claim to Progressive. Progressive then pursued that claim against the defendants and ultimately, I think, lost an arbitration for one and settled another, thereby, I assume, assigning away all further rights to that claim. So I guess what I'm wondering is, how does that claim then also both go to Progressive but still remain with the Mancusos when it's just one singular claim?
Well, that is precisely what the clause means. There wouldn't be a collateral source rule if in fact that didn't occur.
But I think when you look at our collateral source jurisprudence, it all sort of predates the modern insurance contract. It seems like insurers now know that if they're going to be on the hook to pay out people who have policies, they want to make sure they have the rights subrogated to them to go after the wrongdoers. And so I can understand a situation in which you have, 40 years ago when we were writing collateral source doctrine, an insurance policy that contains no subrogation clause that's wholly independent of any claim you have against the tortfeasor. But here they seem to be one and the same claim.
Well, that's you're looking at you're in essence saying that the collateral source rule, which is equally of a great age, has no effect, because if we accepted the way you phrased it, Judge Alicant, then there wouldn't be a need of a collateral source rule, because in fact there would be no collateral source.
There could absolutely be a collateral source. I have a general insurance policy with no subrogation rights that anytime I get harmed, I can make a claim. So I get into a injury with the defendants, I get my recovery from my insurance company, I then also can go and recover against the defendants. And I don't think that is, I guess, a new statement of the law. I see that as sort of following from the Designers of Georgetown case, right? That you have a collateral source opportunity unless and until there's a subrogation clause that covers that claim.
Well, every other case except that one says that there is a collateral source rule, and Judge Penn, in his memorandum decision, addressed it very carefully. The thing is, the way you're articulating it, Judge Alicant, is it appears to be, and I should have reserved 6 minutes and I didn't, and I apologize. The way you're looking at it is that the money is the suit. Under the subrogation clause, I can sue, I replace, in essence, or the carrier replaces my client. And they exercised that. They went after these guys. But under the collateral source rule, that is not what it says. It says, I can go to court, my clients can go to court, and under the collateral source rule, they can recover it, even if Progressive has already recovered money.
Can you just point me to the clause in the contract that you're relying on for that? I just want to make sure I'm reading the same language that you are.
Yes, Your Honor, you'll find that, he said, hopefully he can find it. You'll find that on page.
I believe it's 85 of the
It's
appendix.
85 of the record.
So, Mr. Schwartz, I take that you don't like the designers of Georgetown case, and I agree with you that its reasoning is a bit thin. But I have a very capable law clerk who went and looked around the country, and it seems like there are a lot of cases that are much less thin than designers of Georgetown that sort of unequivocally say where there is a subrogation clause, collateral source falls out of the equation.
But they don't say it here. In any of our cases or the other cases that I cited. Now, I can do a search and there's law in other jurisdictions that reach another conclusion. But the conclusion that was reached in our decisions in this jurisdiction by your predecessors is that there is a collateral source rule. There's a reason why there should be a double recovery. And the second part of the recovery should go to the injured party.
And other than designers of Georgetown, which I read to go against you, what case are you relying on?
They're cited in my brief and when I get back for what may have been 6 minutes or 0 minutes, I'll give them to the court. But let me just answer Chief Judge Blackburn-Risby's question. It's on page 85
Mhm.
and above line 29. And the first paragraph is a subrogation clause, which everybody now agrees is a subrogation clause. And that's a clause that progressive used to go against.
Right.
And now the other side is arguing, well, they have no more right to go against. And they're right. They can't bring a second action, but they didn't. What they did is some clever lawyer wrote the second clause, which is purely, as it starts, when an insured person has been paid by us. And under that clause, which is a contract clause, it's just like a deductible. We're entitled to a certain amount of money. We can keep the deductible that you would have been entitled to. And that's a gist of it. And so what happens as a practical matter is that they use the arbitration method directly, which they're permitted to do. And then what they're entitled to do is they're entitled to allow, and that's what they say in the contract, if you go to court, you're allowed to go to court, but we're entitled contractually to any money we don't recover.
So you read that second clause as the collateral source.
Correct.
To support your collateral source doctrine
Right.
there. Okay. Well, unless my colleagues have any additional questions, we'll come back to you and give you 2 minutes of rebuttal after we hear from appellees.
Thank you, Your Honor.
Thank you.
Good morning, Your Honor.
All right.
Howard Meister on behalf of Chapel Valley Landscape Company.
All right.
To please the
Good morning.
court. I'd like to start by just first addressing some of the points that were just made by the court. I think Your Honors are absolutely correct. This is a subrogation issue, not a collateral source issue. The Georgetown case is the case that's on point, Designers of Georgetown, that talks about, in this instance, the right to recovery.
Mr.
goes
Meister, can I just interrupt you briefly? I apologize, because can you clarify for me? I read the subrogation language in the first paragraph to clearly mean that, with respect to the $28,000+ that Progressive paid to the Mancusos for their car, there was a subrogation that was subrogated to Progressive. Progressive had the right to go after the appellees for it. But what about the other damages that were not paid out by Progressive for the personal property and for the diminution in the value of the parking space? Excuse me, why is there an argument on your part that was subrogated when it was never paid out by Progressive? Why don't the Mancusos have the right to sue for that part of their damages?
They do. Yeah, I mean, there is no basis for that, Your Honor. And that's not the issue that I'm addressing here today, because we will concede that there was no claim made to Progressive for the personal property. There's like 3 or 4 loose items, if you will. I don't know. I think the total is about $2,000 or $3,000 in personal property, the golf clubs and some other matters that were never addressed by Progressive. And they're not part of the subrogation clause, and plaintiffs or appellants are not barred from making that claim.
So, but the trial court dismissed that aspect of their claim as well too, or sorry, granted summary judgment in your favor on it. And so you would agree that we need to reverse that aspect of the trial court's judgment.
Regretfully,
Okay.
I would concede that that was not part of the issues that were being raised at the point. I do want
And
to.
can I just one nuance in there?
Sure.
What about the $1,000 deductible? What about the 29,000? I would think they could go after that $1,000 too.
Agreed.
Okay.
Agreed. So again, I think your honors hit the nail on the head. The subrogation is, and that's what the language says. We have take the rights from you, Mr. and Mrs. Mancuso, to the amount we paid. Anything beyond that is still their right to make a claim. But the issue that we're fighting with today, and we're fighting in court about, was the Mancuso's belief that they're entitled to make the claim for the entirety of the amount. They are seeking the double recovery. That's been the goal from day one. And I do want to just clarify 2 points, if I could, because there were some numbers thrown out that may not be of issue in the bigger scope, but I don't know where the $12,000 comes from. The settlement amount, I think, was 6,000 and change. I don't have it. You reference it. It's in the record. But the amount claimed in the original lawsuit and as part of appellant's brief is 29,000. I have it written down here. $29,097.04. Not entirely sure where that number comes from because the progressive payment was $28,800.97. I did the math while sitting here. In theory, they're entitled to pursue $296.07 if they can prove their damages, because that amount wasn't part of the policy, part of the payment. And again, as the court has pointed out, subrogation only to the amount paid. So, and I don't believe the
Why
$1,000.
couldn't they, I guess if the settlement was 6,000 plus, so if Progressive settlement against the appellees just was 6,000 plus, and they've already recovered the 28,000 plus for the vehicle, and they claim that they have $12,000 worth of other damages in personal property loss and in the diminution in value. Where does the $6,000 apply? Does it apply to the 28 that they already received, or you seem to suggest that it would go to the difference?
No, Your Honor, I apologize if that wasn't clear. I think the $6,000, the payment made by my client's carrier to Progressive to settle the subrogation action, at this point, I think is wholly irrelevant. And I'll explain why. The claim that they're seeking is for the recovery for the vehicle and the personal property. And I want to put a pin for a second in the diminution in size of the parking space. That's a totally separate issue. That has nothing to do with subrogation, has nothing to do with a claim they ever made to Progressive for it. And I'm not standing here arguing on behalf of Progressive. That was a separate issue entirely. As far as those dollars and cents that Your Honor was asking about, the personal property, as we just discussed, they can still make the claim for. What they're not entitled to claim for is the damage to the vehicle that was paid out by Progressive, which in the underlying litigation, they're using that Progressive estimate as their amount of damages. So again, I don't know where that $296.07 difference comes from, and they can try and prove that in court, but that's all they're entitled to because they gave away the rest of their rights when they accepted the $28,800.97 from Progressive, and Progressive stepped into their shoes, as the court pointed out, under the subrogation clause. And this is not destroying the collateral source doctrine. It is, as Your Honor pointed out, this is a build onto it. And I believe, to address counsel's argument of the language, the second part, if you will, I think counsel's trying to say that's the claim to the collateral source still being alive. I find that as more of a catch-all, as if you go ahead and pursue this when you're not supposed to, this is for us protecting ourselves to be able to get that money back from you.
Why do you say when you're not supposed to? I mean, when I read the first clause, nothing says that Progressive has the exclusive right to go after this money. What if, what stops the insurance company under this clause from saying, well, we paid you out $29,000. We have a right to go after these contractors, but we're not interested in doing it. It's small potatoes. We're disinterested in doing that. If you feel like it, have at it. Anything stop them from doing that?
Other than my 20 years working with insurance companies, having never seen that. But in answer to your question, Your Honor, I believe the case law in this jurisdiction says that they forfeit their right to recovery. And if I could, I think when you look at Motors Insurance Corp versus Home Indemnity Company, and this is 284 A second 58, they talk about, if I could, two principles of subrogation. It's a derivative right whereby the carrier succeeds to the right of the insured in relation to the claim or debt for which it is substituted. Secondly, when an insurer pays a sum under a contract of collision insurance, subrogation takes place to the extent of the amount of damages paid. It seems to say that that right goes to the insurer. Whether they pursue it or not is their business, but that right goes to the insurer. It's no longer the right of the Mancusos. Otherwise, you end up in this double recovery stage.
I don't have that case in front of me. I read it, and most of the cases I read involved, I thought, an insurer versus the insured and kind of their rights vis-a-vis one another. This is a slightly peculiar case where it's the tortfeasor who's sort of asserting the rights of the insurer, which is peculiar, especially when you're, I mean, we could be talking about common law subrogation or equitable subrogation, but we're really talking about contractual subrogation. And normally parties are free to waive their contractual rights. So it might be that Progressive has, you know, let's take Progressive's actions out of this equation for a second. Let's say they never pursued construction companies and they just said to the Mancusos, hey, Mancusos, yeah, we could go pursue this, but we're not interested. We're happy. We're happy enough to pay them the $29,000. Why would the construction companies get to assert a contractual right that was Progressive's to waive to preclude a suit if that happened?
The best argument I can come up with for that, Your Honor, is the fact that they stepped into the shoes because, let me do it in reverse, because the insurance company, Progressive, pursued those defendants, these defendants, to recover those monies. That subrogation clause, I think, automatically kicks in. Otherwise, you're facing sort of almost like a double jeopardy. They've already been pursued. They settled one, they lost another. And now I think what the court's suggesting is they can just kick back and say,
it's not that, you know, what I actually think is I find it somewhat peculiar that this wasn't covered in the release. Or correct me if I'm wrong, if it was. When Progressive settled their claims, am I correct that the claims were settled with your client and the other claims went to arbitration where Progressive lost?
Correct.
Do I have that correct?
Yep.
When Progressive settled their claims, I would have thought that there would have been, what they did is they released their rights of subrogation for a sum of $6,000, which basically said to your clients, hey, we're not going to go after you for this. I would think that release would also say, and neither will the Mancusos, hey, Mancusos, sign this release as well, as Progressive would have had a contractual right to demand that they do, because the contract says they have to, you know, sign whatever forms Progressive wants to pursue their subrogation rights. But I don't think that happened here, which just makes this, to me, I find it slightly curious. Like, why isn't this addressed in the release? And if it's not addressed in the release, what business do you have of asserting Progressive's contractual rights?
two-part question. So why it wasn't
Might have been a 7-part question.
It might have been. Why, I believe, I'm speculating a little bit, why it wasn't asserted in the original release is simply because I don't think Progressive cares. They're getting their money, and what they're releasing is their subrogation right and claim against my client. That claim is worth $29,000. That's the whole purpose of the settlement. They're paying a portion of the money so they don't have to go forward and prove their case and maybe not prove their case as others, it happened with others. But that's what my client was buying, was their piece for the entirety of the subrogation claim that Progressive has the right to. Now, interestingly enough, the Motors Insurance Corp case that we talked about had a similar sort of fact pattern, because in that case, the claimants there were trying to make a claim for utilizing a release similar that they hadn't signed. And the court said, you can't do that. They didn't sign the release, so you can't do that. But I think in this case, This is a subrogation right Progressive has for $29,000 for the amount that they paid. They negotiated the terms of a settlement with my client, essentially, its carrier. And that is for the entirety of the claim. Otherwise, what's the point? Why would my client's carrier sign this release to only have to come back and fight this a second time, which is what we're doing here? And I would point out that there were approximately 40 vehicles that got destroyed in this collapse. And there's only one that's pursuing this claim because all the others understand that the subrogation rights went to their insurers and those claims are gone. And so that's all we're dealing with today. I see my time is up, but if there are any other questions on this issue of subrogation and collateral source, I'm happy to address it.
So again, I know you're not arguing the appellant's case, but you don't dispute that the Mancusos still have a right, theoretically, to pursue the personal property damage and the diminution of value of their space because the size of their parking space shrunk, essentially.
Two different issues, Your Honor, if I could. And my co-counsel has said that I can go beyond and go into the time if necessary, Your Honor. So if you look at page 3 of the brief, and I'm not suggesting you have that in front of you, appellant's brief, it breaks down what their damages claims are. And they're separate categories, if you will. And no, I'm not arguing appellant's case, but I have candor before the tribunal as much as it pains me. So the answer is yes, I believe the last 4 items identified. Well, and not entirely, because one of them is reimbursement for rental vehicle 97817. I believe 600 and change was covered under that progressive settlement. The equipment destroyed.
Sorry, not progressive settlement, but progressive payout to the
Sorry,
Mancusos.
I apologize. Yes, I misspoke. When part of the subrogation settlement, if you will, with Mancusos. The equipment destroyed, 2147.98. The personal miscellaneous personal property, 611.93. And I don't know what it is, but loss of personal property in the space, 134.35. Those, in theory, are still viable claims. I want to take the pin out of that diminution of value of the space.
Right.
That is an entirely separate claim that the court addressed in a separate issue.
Now there's some dispute about whether the court ruled on this diminution of value. Some issues related to it, the motion in limine to keep out the DCRA citations and violations.
Not what I'm referring to, Your Honor.
Okay.
And since you brought it up, I'll just very quickly touch on that. That was just a motion to eliminate, and there was no ruling. And I think our brief, and I'm not going to go into it too much at all. I think our brief addresses that in 2 different parts. First, even if it was a ruling, it's a motion to eliminate ruling that can still be changed up until the time of trial. So it's not final for this court to look at, but it wasn't even a ruling. What the court said in the transcript is clear is, I'm telling you where I'm leaning. I'll let you know before we get to trial. So I don't think that is ripe for any discussion here today. And that's how we address it in our brief. But the diminution in size of the parking space, the $15,000 portion of the claim, I think that was addressed, and I may be putting my head in the lion's mouth, in a different dispositive motion that the court ruled on earlier. And that was the proximate cause issue. And we haven't addressed that here today, but that decision by the court is what removed the parking size, if you will, the 8-inch diminution, alleged diminution inside
Right, that's
the
the
parking
partial
space.
grant of summary.
Correct.
judgment.
That occurred way back.
Mhm.
And when that ruling was made by the court, that took out the parking space claim, if you will, the size, the shrinkage in the parking space size or the value of it. And there are a whole host of issues with that claim that haven't really addressed here today, but that was a separate ruling. That's why I kept saying the $15,000 is part of the subrogation action. It's not part of that claim for the crushed car. The subrogation action is simply the car got crushed. We reimbursed you under your auto policy, and it's all right now.
But appellant is separately contending that his claim should be remanded for further proceedings on the request for $15,000 for the diminution of the parking space. And I'd like you to just speak briefly to why wouldn't this be potentially, reasonably foreseeable, given that the necessary sort of result of your client's malfeasance was that the parking garage had to be rebuilt. And it seems like it could be reasonably foreseeable that it would need to be rebuilt in such a way that would not be identical to how it had been before.
If I could, Your Honor.
If your colleague wants to speak to that, that's
That
fine
was,
too.
that was the split that we were looking at, Your Honor. It just never came up in the front end, so if I may,
Thank you, counsel.
thank you. Appreciate your time, Your Honor.
Thank you. May it please the court. James Howard on behalf of the appellees. Just to address that precise question is what I prepared for today. While we think the issue of but-for causation is clear, if it's proven there was a collapse, we think when you look at the proximate causation case law, terms like reasonably foreseeable, natural and probable, ordinary versus extraordinary come up a lot. And we think there's a difference between the reconstruction and the impacted areas versus the decisions that went into actually how are we going to reallocate parking spaces to these tenants in a separate building that happen to share this garage. And we just think it's too far attenuated from the collapse to say, I'm an individual owner of an individual space in the garage that you impacted. So I lost 8 inches on the reconstruction, but for the collapse, this wouldn't have happened. Now I'm owed that money. We just think it's too far attenuated. The foreseeability analysis, you also see scope or sphere of harm come up a lot. I just don't think it's in the sphere or scope of anticipated harm when our clients are performing construction operations that they're going to impact this one space. Obviously, the garage as a whole was impacted, but it's just such a minute, individualized, specific claim that we think another point I should have brought up is the decisions that went into redrawing the lines or reconstructing. Also, we categorize as an intervening superseding cause that were not foreseeable.
And why is that not a question of fact, right, as to how far the chain of foreseeability goes?
Right. When we briefed this, we submitted these arguments to the trial judge. She decided that it was intervening and superseding. We stand by that argument, but I think reasonable minds could differ, but in our view and in the trial court's view, it was intervening and superseding and not a question of fact. I think the key being just how hyper specific this one claim was. And I think when you talk about foreseeability, you talk about a policy element, approximate cause. It's sort of, we put in our brief, the limitation of liability. How far do we want to stretch out tort liability? When I think I was reading one case that said the limitation of liability for torts, you're really at the mercy of the human imagination. It's really only limited by the human imagination. So a creative lawyer could come up with any number of claims that this collapse impacted.
So let me give you a hypothetical. So let's say there's someone standing in the garage when it collapses and they get smushed. I assume that you would agree that you could have a claim lie against you for the damages to that person.
Yes.
Okay, so then, the next day they have to come and start rebuilding the garage. And in doing so, the worker trips and falls and hurts himself significantly. Is that not a reasonable, foreseeable result of your wrongdoing that led to the collapse?
Just to clarify, who trips the next day? I'm sorry.
The worker that comes in to remediate the collapsed garage.
I would say well, I think that Iowa case that we cite, I obviously know that's not binding, addresses that issue where the contractor was on a ladder to fix an issue in the ceiling. He wouldn't have been on that ladder but for the issue in the ceiling, but his own carelessness or some other issue, I can't remember, caused him to fall off the ladder.
Right. I mean, that seems different to me because I think if I'm remembering that case, like the cause of his harm was that he was up there to hang something and he dropped it on himself, right? That does seem to be a break in the chain. But I guess I'm wondering here why someone falling in the course of a collapse is you concede is recoverable, but not someone falling in the course of remediating your collapse.
Right. Well, I think the person falling remediating would have a stronger argument than a parking space from, that's reconstructed months later. But I also think, going back to the policy element, at what point do we cut off tort liability where there's contracts and there's insurance things to deal with these, where if we hold a tortfeasor liable for every single thing that could come up when they do something wrong, I think that's setting bad public policy. But to answer your direct question, I think the person coming to remediate it has a much clearer claim than, a tenant in who their property was damaged. We're not disputing that, but it just was not our client's decision in any way how to reconstruct that garage. And we think that makes it as not the proximate cause element not met here.
And in assessing the foreseeability question, does it matter whether the garage could have been rebuilt identically as it was? Because it seems like if there was no circumstance in which it could have been rebuilt, perhaps then it is foreseeable that this is a likely cause that should be economically recoverable. Whereas if, there was no way in which it could be, or rather, if there was a way in which it could be rebuilt identically and policy choices were made by someone different, you would see that is an intervening.
I think so. I think we put in our brief that if there was a circumstance where it had to be rebuilt in a way that negatively impacted the Mancusos, they would have a claim, or arguably could have a claim, but there's no evidence in the record that happened. And I think our point on that was whoever decided how to reconstruct the garage, there's that situation, there's drawings, there's construction, and then there's the actual decision on how to allocate these parking spaces that none of us know what went into that decision. And I just don't see how our clients could be responsible for that. And it seems like a grievance that's taken up with the property management, who's in a better position than I think the tort law to address issues like that.
All right. Unless there are any further questions from my colleagues, thank you for your argument today.
Thank you, Your
We've
Honor.
allotted 2 minutes to Mr. Schwartz for his rebuttal.
Thank you, Your Honor. In relation to Judge Ali Khan's question previously, the cases that are cited on page 3 and 4 of the one to support the principle.
And so, Mr. Schwartz, I read those cases and none of them seem to involve subrogation clauses.
No, and the reason they don't involve subrogation clauses is that this is a particularly rare circumstance where, in fact, the value of the suit, if we call it that, is more substantial than the amount that would be a subrogation amount. And it just hasn't come up to this court because it's always settled down below. This case should have been settled. So, but what those cases do is they absolutely support the idea of a collateral source rule. And if you have a collateral source rule and it's subrogated, the case is subrogated, then you no longer have a collateral source rule because the insurance company doesn't have the circumstances, i.e. they have not been paid by a collateral source. Therefore, the insurance company cannot, in essence, get a double recovery. And throughout this case, the two defendants keep talking about, double recovery and double jeopardy, but that's the whole point of the collateral source rule. The collateral source rule says there will be double jeopardy because tortfeasor should be punished.
Sorry, I want to follow up on that. My sense of the collateral source rule is that there's double recovery that redounds to the plaintiff, not that there's double liability on behalf of the tortfeasor. And so my sense of a typical collateral source situation is I have a life insurance policy and I get hit by a WMATA bus. My husband and my beneficiaries get the payout from my life insurance policy, but my estate also gets to sue WMATA. And so it might be that my estate ends up with a full payout from the life insurance and a full payout from WMATA, but that doesn't mean that any one tortfeasor has been put on the hook twice.
Well, you're exactly right, Judge Ali Khan. This case we're in now and appealing has nothing to do with that second clause, that second paragraph, which is a contractual clause, which was put in by progressive lawyers that said we're entitled to this money. It's not based on subrogation. It's, we're entitled to this money and you won this money and we don't care whether you pay it out of the money you won or out of your monthly allowance from your very wealthy grandparents. We're entitled to X amount of money.
And so
And
I have one final question about that, which is I read that paragraph as an anti-collateral source rule, because it says, hey, party, if you recover money from somebody else and we've also paid you, you need to pay it back to us because you're only allowed to recover once. And that to me just seems to be the natural effect of a proper subrogation clause.
Well, I agree with you that it is, in theory, a anti collateral source clause, and that was what it was meant to be. And once the court decides what the law is, then I go to desk or whatever that agency is called in the district, and I say, you've got to clarify the fact that insurance companies cannot defeat the collateral source rule. But I can't do that until this court decides. And this court, based on the cases that I've cited, need to affirm the collateral source rule as a viable rule. And if the court decides against it, then it's not a collateral rule anymore. There is none, because there is nobody who can exercise it. And quickly, because I know I've only been given 2 minutes, let me just point out that we now agree that it should go back. Both sides agree it should go back, even if it's over that small amount. And the court has before whether or not there's proximate cause in relation to the collapse. And I think Judge Alicant has invested or spoken about that very well. But double jeopardy is okay. That's what the collateral source rule is all about. And the reason that there haven't been a bunch of suits, which is not on the record, is because of the narrowing of the parking space. He would not have sued for, he wouldn't have found a lawyer who would sue for $29,000. That was the point. And what he failed to mention is that there is one case involving the collapse in people, and that is a multi-million-dollar suit of somebody who was in his car when it collapsed and was injured. And there were other suits that are now pending, set to trial, which deal with the collapse. It just doesn't deal with this very narrow portion of the collapse. Finally, as you point out, Judge Blacker-Brigsby, there are other issues in this case, and both sides, I think, have done an excellent brief. And I know Judge Alicant is familiar with briefs that, because that was her job to review them and find out that I was wrong. And consequently, I would urge the court to read, I'm sure you've read the briefs, but if you read them in relation to the arguments that were raised before you, then I think that would be a useful exercise. Thank you very much.
All right, thank you. We'd like to thank all counsel for your briefs and arguments today, and we'll take the matter under advisement. Our third and final case for argument this morning is Lawrence E. White versus United States. All right, good morning.
Good morning. May it please the court. My name is Cecily Basquier on behalf of appellant Lawrence White. I'd like to reserve 3 minutes for rebuttal. For today's argument, I'd like to focus on Mr. White's ineffective assistance claim related to the scope of the search, and I will rely on my briefs for the arguments related to the Franks versus Delaware claim. On the scope of the search claim, the government has made a tactical decision to defend the trial court's judgment only on the question of the prejudice from the failure to suppress the contents of the duffel bag. And those contents included both this distinctive black and white t-shirt that matched the description in the video for the second robbery, and also the other t-shirt and shorts that matched the description from the first robbery. So I therefore like to argue solely on those grounds today. And because the contents of that duffel bag, had they been suppressed, it would have transformed the whole focus of this case and the way that it was tried in the trial court back in 2012. So this court should therefore reverse and remand this claim for a new trial.
So it seems to me the hardest point against you is the fact that there was an eyewitness who was unequivocal in her identification of your client. And so what work would the duffel bag not be doing if it had been properly suppressed?
So the duffel bag, and especially this distinctive t-shirt, the shirt was like a calling card for Mr. White. So the witness describes it in her testimony, and she talks about the black shirt with the white design on the front. It's visible in the video, even though the video is so low quality. And if that hadn't been there, this could have been a case and should have been a case about the reliability of eyewitness identifications. But because there was that physical evidence that, relatively speaking, was relatively infallible, it wasn't prone to the kind of human error that an eyewitness identification would be. It changed the focus of the case in that way. So
Now,
if it had,
am I right? Defense counsel did not put on an expert about unreliability of eyewitness identifications, right?
correct.
And it would be, and there was no accusation in the proceedings immediately below that that was ineffective assistance, that would have been, that was a deficient choice, presumably because that evidence is usually introduced when you're dealing with stranger identifications. And this is not quite that, right?
I think, Your Honor, this is like a stranger identification because Ms. Mendez had at most a passing familiarity with this person who, like others, would come into the store. But she also said she was too busy to really be paying a lot of attention to them. It's not like someone that she spent a lot of time talking with or knew well. And these stranger identifications or these kind of passing familiarity with a stranger identifications are notoriously unreliable.
So, but again, I'm correct that there was no evidence of unreliable identification. There's no expert evidence of that sort, right? And you have not alleged that that was deficient performance.
Correct, Your Honor. And a big part of that is because with this T-shirt evidence, it wouldn't have made sense because the jury didn't need to grapple with the reliability of the identification because it had this shirt that was going to be really hard for anyone to say, well, that's not the same shirt that we see in that grainy video. So even if it was all about transference and weapon focus and whatever an eyewitness expert would have talked about at trial, it was essentially unnecessary because of the physical evidence that came in.
And am I right? Just because you referred to it as a calling card, so I want to make sure I understand the record correctly. There was no testimony that the victim in this case identified him based on the T-shirt he was wearing. That this was a shirt that he wore, and so, even if she hadn't looked at his face, she would have known it was him because this is a shirt that she's seen him in before. There's nothing like that, right?
No, but the one thing that she identifies when she's talking about what she saw with the robber in the second robbery is she says he was wearing a black shirt. It had a white drawing on it, and then we see that in the video as well, even though the video, it's very hard to make out specific details, but it's clearly a black shirt with a white drawing. And so then once you can look at the photos of the actual T-shirt that was seized from the top of this duffel bag, it matches up against both what she said in her description and her testimony and what the jury could see in the video. So even though it's a black shirt with a white drawing on it, it could have been a black shirt with the white thing that said, hey, I'm Lawrence White because I'm found in the bag with Lawrence White's identification in it.
Well, maybe. Although let's talk about some of the other evidence. There's also a police officer who from the surveillance video immediately identifies your client, correct?
Yes.
No suggestion that he was basing that identification on the T-shirt, right?
No.
The peculiar gait and ears, if I remember right, had something to do with the identification. I couldn't make much of the gait and ears from the video myself, but I think that factored into the officer's ID, right?
Yes, Your Honor. The officer specifically talked about this gate, although the video only shows a couple of seconds, which to me, I think I would not have been able to identify anyone from that bit of the gate or see the ears clearly in the grainy video. But again, the officer's identification from that video is prone to the kind of human errors. I mean, she did say that she had known Mr. White from, maybe 2 conversations in the preceding weeks in the neighborhood, but a jury didn't have to credit that, just as it didn't have to credit Ms. Mendez. But it didn't need to stop and think, well, do I believe her? Do I not believe her? Because it had this clothing, and not just that T-shirt that we've been talking about, but also the only thing that corroborates the description from the first robbery where there is no video is the blue shirt and the black shorts that are found in that.
Yeah, you didn't make much of that in your brief, and I'm surprised you want to raise it now. I mean, I don't recall those being terribly descriptive. Was it blue shirt, black shorts? I've got those.
Yeah.
That doesn't seem like a lot. It doesn't seem like that is really gonna, I think you could go into just about anybody's house and pull out a blue shirt and some black shorts. Probably,
I
maybe.
think, Your Honor, it's certainly not as important as that black and white T-shirt because, again, of the matching up both with her testimony and with the grainy video. But it's still there. And in closing, the prosecutor did talk generally about this clothing that corroborates the sort of physical evidence that corroborates the eyewitness.
And
So-
part of that is also the jeans, right? I think where the government says that was as distinctive, if not more. I'm not sure if it's as or more, but somewhat distinctive, the jeans, at least, I think there was talk in the closing about them being embroidered on the back pockets. I can't say that I can see that in the video, but those jeans would have come in regardless, right?
So I think, Your Honor, we argue in the briefs that the jeans would have been suppressed, but the court doesn't even need to reach that because it's not really about the jeans. As Your Honor says, you can't see that embroidery in the video. The witness, when she's describing the robber, doesn't talk about, oh, I saw these embroidered jeans, so the jury can then say, oh, let me match the embroidered jeans to the ones in the photo. In her mind, she's talking about the T-shirt and it's about the T-shirt. And so this case doesn't turn on those jeans.
But it seems like the jeans are doing something separate, which is that he was wearing the same jeans as in the video when he was arrested, right? So it's not that the eyewitness identification turns on it, but the police's arrest sort of adds additional evidence.
So yes, Your Honor, she doesn't talk about it, and he was wearing them when he was arrested. But in terms of, let's say, this prejudicial effect, they're not doing as much work as that shirt is doing because of the way the shirt matches up in so many different ways here. And the jury had that video, and the court can watch the video as well and see, does it really show as clearly what the officer says it shows? And I would proffer that it doesn't. So we've got fallibility of eyewitness identifications, fallibility of essentially an identification from a poor quality video that doesn't necessarily show the things the officer is saying that it shows. So what the jury has is it has this tangible evidence, and it doesn't have to then deal with, do I believe them or not? Because it sort of makes it much more of an open and shut case. If you take out that shirt, and again, less important, but still there, the other clothing from the duffel bag, then suddenly the case is tried in a different way. Maybe presumably, hopefully that eyewitness expert does come in.
Do we have, I take it the shirt was a physical exhibit at the trial court, is that right?
Yes.
Do we have a picture of it?
Yes.
For all I know, it doesn't actually match what's on the video, and so it's not powerful evidence at all. But I don't recall, there's a picture of it in the record?
Yes, I believe that there is a picture of it also in the limited appendix.
Okay.
That the court had. I hope that it is in color. I'm not sure if the size of the file meant that it had to become black and white, but I can certainly make sure that's provided to the court if it doesn't have the color.
I don't doubt you. I just don't recall seeing it, but I probably just
Yeah.
missed it. I think I see it now. Okay, yes, it's at government's exhibit. It's at page 18 of the appendix, government exhibit 82. Okay, thank you.
I guess my question is about, you have 2 witnesses, eyewitnesses who identify appellant. Yet no eyewitness identification expert was called. But I hear you saying today that had it not been for the T-shirt, perhaps that would have been a refocusing of the case. Tell me again your argument as to why, sometimes you have one eyewitness identification that might cause the jury to doubt the identity of the appellant. But here we have a double identification, as well as other evidence in the record. I'm still struggling, the embroidery that's alleged to be on the jeans in the video was difficult to see. I guess you've made your argument, but I'm still struggling a little bit with the strength of it. And I know you wanted to submit on your briefs, the argument in your briefs about the Franks motion and whether or not the affidavit and search warrant were valid. But I guess I'm going to ask you if there's anything else you want to say in support of that argument as well.
So to go through your honors questions in reverse, there's nothing further at this time that I'd like to say on the Franks argument. When it comes to the identifications, the question here, it's not a sufficiency of the evidence case, and it's not about counting up the number of things that the government introduced. It's about, is there a reasonable probability of a different outcome, and is there enough to undermine the court's confidence here? And even with, so that there's only the one eyewitness, and there's a weapon and it's a short incident and she doesn't know this guy well. And then the other identification is also an officer doesn't seem to really know him well, but she's watching a video that is not very clear, which raises similar kinds of questions of transference and just general sort of human error. We think we recognize someone, but we are often not as right as we think we are. So
that's where the expert,
it is
eyewitness identification expert would come into play, and there wasn't one here.
It is, Your Honor, and there didn't need to be, because even if an expert had come in and said all of that, the jury would have said, but we've got the clothing. Like it's enough to give us that confidence in the reliability that they wouldn't have had without the contents of that duffel bag. So.
There's one other piece of evidence that if you might talk about, and it was the arrest process itself, which is, people have all sorts of reasons why they might not want to answer the door if police are there. But if my memory is right, police were there for what, 6 hours? That's usually not the type of thing that somebody's going to hole up in, except for something quite serious. And I understand you. Was there evidence that in fact there was some parole violation, and that was the explanation for that?
So that's what Mr. White testified at the hearing. He said that yes, he was under supervision, under CSOSA supervision. He had tested positive for drugs and he had failed to report, and he thought they were coming to arrest him for those violations.
But I take it at this trial, putting the 23-110 hearing aside, that the government made some consciousness of guilt argument based on his reaction to the police thumping at his door, right? And that there was no testimony by him or evidence by him offering the contrary explanation. Is that right?
That is correct, Your Honor. But again, we have in this trial strategy that was affected and determined by all of the evidence that was coming in, including this clothing. I think it should have been a very different looking trial with potentially, probably, hopefully different decisions by defense counsel about how to structure it. And when we look at defense counsel's closing, it unfortunately looks like the closing of someone who feels like he doesn't have a case. And so there's, again, not as much, I guess, value to be gained by challenging the government's consciousness of guilt argument under those circumstances, because there's the clothing. So one hopes that, in a retrial with this evidence properly suppressed, that competent defense counsel puts on the identification expert, raises issues about consciousness of guilt, and really takes on the government's case in a way where the jury can see that it is not nearly as strong as it appeared to be back in the 2012 trial. So I see that I have used my time. Thank you.
All right, thank you. We'll still give you a couple minutes for rebuttal as well. Thank you.
May it please the court, Brian Hahn for Appellee of the United States. The trial court in this case properly denied appellant's 23-110 motion because he failed to establish prejudice from his attorney's failure to bring the scope and particularity of the warrant challenge.
Can I ask you a threshold question?
Sure, Your Honor.
So this warrant, putting it to one side, whether it included other evidence besides the person, seems like an odd way to get into a building to search for a particular person. Is this the type of warrant that you would use when you're trying to do that?
Your Honor, I do think it is a strange warrant. I think you would. I think that if you're looking for a person, and if the police here sort of are checking all of their boxes, trying to make sure that they can enter the residence to look for a person, that you could issue a warrant that is restricted to, like, you can search the residence for a person. That's certainly possible. I don't see anything wrong with issuing a warrant like that.
Is that what the warrant here did
I-
authorize? Should we take the government's lack of strong challenge in their briefs as a concession that there were some problems with this warrant?
I think the government isn't relying on any findings about the warrant or counsel's deficiency on that because, the prejudice question is very clear in this case. I think it's a difficult issue. There's the scope of the warrant and then whether or not it's particular and whether or not there's the search warrant affidavit and then the next arrest warrant affidavit that was signed by the same judge earlier that day. I think it's very messy. It's a very messy record, Your Honor. So, this court doesn't need to reach that issue. And certainly the government hasn't argued it in this appeal.
They're kind of two questions. I just want to make sure I understand. And I think you've adequately answered it, but I just want to make sure I understand. One question is sort of, was this warrant deficient for lack of particularity? And I don't take the government to be contesting the defense's argument that it was. It does not say you concede it, but you're just not going to fight that battle here. There's then sort of a next question, which is, and was it therefore deficient for counsel not to raise this type of challenge? One doesn't necessarily follow from the other. Sometimes, non-deficient counsel can miss meritorious arguments because this is just such a peculiar arrest warrant. The affidavit was there. You could have been confused. But I understand you to be not taking issue with sort of either of those steps, and you're purely on prejudice. Is that right?
That's correct, Your Honor.
So let's hear your prejudice pitch.
Sure. I think first of all, as the court's mentioned, there is a unequivocal identification by the eyewitness in this case, Mr. Mendez. She knows the defendant because she's seen him enter the store before trying to sell things to other customers. She has the chance to interact with him twice in the office because he comes and robs the laundromat twice on two different occasions. She testifies that she's looking at his face while he's in there and that she recognizes him. In fact, she tells the first officer who responds to the first robbery that she did recognize him, and then tells officers who respond to the second robbery that he was the same person.
And am I remembering the record correctly that she actually sort of focused on his face the second time to try and remember him because I guess the security camera hadn't been working in the prior robbery?
I don't know. I don't remember if she tied it specifically to the security camera, but she did testify she was looking at his face so that she could remember him at the second robbery. Yes, Your Honor. The photo array identification, of course, takes place, I believe it's the day after the second robbery. And so it's very close in time. She unequivocally and quickly identifies him as the person in this photo array. We also have the officer's identification of him, Officer Sakulich, who her testimony was that she had conversations with him 2 times recently, and that she had seen him several times over the course of that summer, saying hello or, briefly passing each other. And that the week of the second robbery, she had actually seen him, and that even though she didn't talk to him, he got into an argument with her partner. And so she testifies that she watches the video when she responds to the second robbery, watches the surveillance video they have there, immediately recognizes him, the person in the video as Mr. White, and gives several reasons why she thinks it's him. She describes his baldness, his ears are sticking out somewhat, and she talks about his gait and the way that he walks. And I take Judge Steele's point that he could not really tell these things about the video, but again, as the government, as I made in my brief, like that's sort of the whole reason why we allow lay opinion testimony from surveillance videos that aren't, the most videos that aren't crystal clear, that the jury is not going to be able to see these things that someone who is familiar with someone is able to do. So we have the officer's identification of the defendant. A few other things that we've had, of course, this court's already talked about the jeans, which I think were described as distinctive and were described as having embroidery on the back pockets. I believe the appendix also has pictures of the jeans, and of course the court has the video now because the court requested it, and the tennis shoes that appellant was wearing at the time that he was arrested.
Counsel, how do you respond to appellant's argument that it's not just mere sufficiency when we're looking at the eyewitness testimony of the witness who saw him come into her establishment a number of times or on more than one occasion, and then the police officer's identification, that we have to look at whether the clothing evidence in the bag might have triggered a different strategy of the defense, such as calling an expert on eyewitness identifications.
So I don't think the standard is whether or not it would have triggered a different defense. And maybe that is part of the analysis, but the standard, at least from Kimmelman, is whether or not there's a reasonable probability that the verdict would have been different absent the excludable evidence.
Right. And I didn't mean to characterize what appellant counsel said, but why isn't that the case here if we take into account perhaps the value of calling a different witness, like an expert on identification, that might have been more another path that the counsel could have taken, but for this additional clothing evidence?
Sure. I think two things, Your Honor. I think first of all, counsel is not precluded from calling a witness, an expert witness. And I don't have great familiarity as I stand here with what an expert witness may testify about. My sense of it is that Judge Steele was right when he said that a person who knows, who's making an identification of someone they know, is less likely to be affected by any of these sort of things we throw out here, the fallibility of eyewitness identifications, whatever other arguments that appellant might make about those. So certainly counsel could have called an expert, and we don't have one in the record. The second point is sort of related to that, but it's the appellant's burden, of course, in a 23-110 motion seeking, reversal for ineffective assistance of counsel to show that there's prejudice. And I think that there was no mention of, an expert eyewitness identification. Sorry, that was a little garbled, of an expert for eyewitness identification, either at trial or in the first 23-110 go around, or on remand. I think it's appellant's burden, if appellant's going to argue that an eyewitness expert would have made a difference in this case, to put on an eyewitness expert at the remand hearing to testify about what the science might be. And here, on this record at least, we have no information about what an eyewitness expert may have testified to. And that's appellant's burden. And because they didn't put that on, and they didn't claim that counsel was ineffective for not putting on an eyewitness expert, they can't show prejudice based on the failure to call an eyewitness expert, even assuming the t-shirt is suppressed. And so I think there's just another couple points of evidence that we have in this case. Of course, we talked about the consciousness of guilt of appellant, sort of holding up in his girlfriend's house for 5 to 6 hours as the police, sort of banging on the door and trying to get him to come out. And as Judge Steele, I think, pointed out, there was no evidence at trial, and certainly no credited evidence at the 23-110 hearing that he stayed there for any other reason. He was avoiding the police for any other reason.
I thought there was some testimony that he was recovering from heroin withdrawal and was bedridden.
Sure, there was testimony at the 23-110 hearing. He said and he said he sort of ignored the police because they didn't want to come out. But again, I said no credited testimony, and the trial court at least explicitly discredits appellant's testimony at the 23-110 hearing. And says, I think just sort of in that footnote, just says blankly, appellant was not credible. And so I don't think we have any real evidence combating the argument that was made at trial, at least, that appellant was hiding from the police because he knew that he was on the hook for these two robberies. And then finally, of course, there is the evidence that, the girlfriend's house and appellant's house were very close to the laundromat within a couple blocks, I believe. So at least he had the opportunity to be there, and he was very close. So because of the strength of evidence, what the panel on direct appeal said in the in the MOJ, that was very strong evidence, and didn't mention the T-shirt when I discussed that. And of course, the trial court in its order determined that the evidence was so overwhelming that even if this T-shirt had been suppressed, even if the pictures of the clothing in the duffel bag had been suppressed, that the verdict would not have differed. And because appellant has failed to establish prejudice, the government would urge this court to affirm the judgment of the trial court. If there are any questions about the Franks issue, I'm happy to answer them, but otherwise, we'd ask the court to affirm.
All right, thank you.
Thank you.
Ms. Basquiat, we allotted 2 minutes for your rebuttal.
Thank you, Your Honor. I'd like to just start by referencing the case that I raised in the 28K letter last week, a supplemental authority, Rose versus United States. The government's made clear again today that it is not making arguments on the deficiency prong, and this isn't a case that raises any special considerations why the court should go beyond that litigation decision of the government to address those issues. Sua sponte, the court doesn't need to do that, and the court should resolve this question of prejudice in favor of Mr. White. The government mentions that the burden would have been on Mr. White to bring in an identification expert at the 23-110 hearing. That is not the, I guess, the core of the prejudice argument we're making right now. The core is that because the T-shirt came in, it changed the focus for the jury as well as for defense counsel. And the jury didn't have to ask itself questions about the reliability of the either Ms. Mendez or the police officer. It didn't have to grapple with questions of consciousness of guilt. And had that stuff not come in and the jury had to grapple with that, even without having an identification expert, it's fairly well known that misidentification is a problem, and it's quite reasonable for a jury to want something more to show the reliability, like to trust that these witnesses were not making mistakes. And so without the T-shirt, it is reasonably probable that the outcome would have been different, enough to undermine the court's confidence, because the jury didn't have to grapple with any of those things. Had it grappled, it very reasonably could have questioned them for all the reasons in the brief and that I've talked about today. If the court has no further questions, I would ask again that the court reverse on these grounds and remand for a new trial. Thank you very much.
Thank you. All right, we'd like to thank all counsel for your briefs and your arguments today, and the case is submitted.
All right.